Welcome to the Retirement Income Source, where it's all about investing for income the old-fashioned way. What do I mean the old-fashioned way? Well, if you go back in history, after the Great Depression, and let's get back into the 60s and 70s and going into the 80s, if I was to go back in time, your parents and even grandparents may have remembered some of this if they're still alive. If they wasn't. Dividend-paying stocks were very common. Matter of fact, for whatever reason, entered the 90s, people started getting away from that concept of investing for dividends, the old-fashioned way, and started focusing more on growth because by accident, growth actually was the next big thing, and so most people started investing for growth, and of course that's where a lot of the knowledge and the training now comes from, is total return investing, and that's the reason why a lot of advisors don't talk about investing for income the old-fashioned ways, because they've seen such a robust, mid 80s to all the way to the end of the 90s. And of course, we've also seen a really good market since 2013 till now, that what's the point, because, we're going to have the wind at our back long enough to be able to get us through retirement. Well, that may be okay with some of you all, but that's not okay with me. Keep in mind, it's just a philosophy, right? So it depends on which side you want to be. All I know is whenever somebody goes into retirement, what they got to realize is they're no longer buying shares in the new plan that's been set before them if they stick with the total return plan. The only way you can buy new shares is if you have dividends or interest that are coming in from those mutual funds that you're invested in now. Well, guess what? The amount of income that you're getting from those, from the income method, I'm talking about from the I method, is not enough. So now you're selling shares all the way through retirement. And so that's what you've got to learn and understand. Because that's the conclusion I came to after doing this and being in this industry for the last 20 years. My goal is to share with you my experience. It's up to you whether you listen to the show and you want to investigate further and get informed or not. At the end of the day, none of us want to let go of the steering wheel. And so we should have somewhat of understanding how we're spending our money. So that's why I like investing for income the old-fashioned way. Because if it's done correct and I've got the right tools in place, then I'm going to get more mileage out of my money. We thank you for tuning in today. My name's Tim Sparks, and our show is sponsored by Sparks Financial Group, a financial firm right here in the heart of the Bluegrass, Lexington, Kentucky. Today, we're going to be talking about estate planning basics. If you forget to at least do a will, then you don't have nothing to worry about. I'm being silly here. The state will provide one for you, but I'm willing to bet you could do one better than they could. So at a minimum, everybody should have a will. In most cases, I do run across that, but to me, a will in of itself is not enough. There's other documents that should accompany that will that I'm starting to see with our own clients. Matter of fact, there's documents like the durable power of attorney, which are financial decisions. If sometimes the husband or the wife will make each other the power of attorney or the durable power of attorney over their financial decisions in case they get to the point where they don't feel comfortable making their own financial decisions. And then they may even make a secondary one, which is always recommended by the attorney as well. Keep in mind, these documents, the reason why they're recommended is because, first of all, thank goodness that our attorneys that we work with here locally and also a national group suggest it. Not only that, it comes along with the package, and it should come along with the package. When I mean a package, whenever you get a will and other documents, and the durable power of attorney is just one of them. It's a financial decision like type of power of attorney. And I'm going to explain to you, some recent reasons why with clients that we work with, why they use this document already as we speak. There's other documents like living will. You don't want to be in the the hospital. I don't know if y'all remember Terry Schiavo, but you don't want to be in the hospital, and you need you may be incapacitated, maybe even to the point where you've been in coma, or they put you on one of those machines to try to keep you alive, because every day you stay in the hospital, the cost is going up. And you may say, well, I don't want to be in this position. I don't want it to affect my spouse who's outside, not going through this. And so I would like for somebody to pull the plug if this instance was occurred. That's an advance directive. There's other documents like a healthcare power of attorney, which my mother, for example, we have RNs in our family that comes along and helps her because she's like 82 years old. She doesn't feel comfortable making decisions with her prescription drugs that are proposed to her from her doctor, so she wants somebody to step in that's in line with that area. And this could be a pharmacist, it could be anybody can do this, but you want to always have somebody in place to be able to help you to make decisions while you're alive. There's many other reasons why that your local or state attorney can provide for you in case, and again, the name of the game here with estate planning is to have an estate plan and understand the documents, and that's what we do. We help our clients be able to understand the documents as how they're proposed to our clients because we work with people every day, and we've seen where these documents have came into play. So if this makes sense to you, I want to get a commission report in your hand called the Estate Planning Myths. Matter of fact, we're going to be talking a lot about the myths. I'm going to give you stories of clients and issues that they've had and why they had trust and regretting they didn't have wills or trusts and so forth. And thank goodness the attorneys we work with or attorneys they work with prior to working with us have been able to have this plan. And therefore, if you have a plan, it's great. It's better to have and not need, and need and not have. And so I want to get this report in your hand. Again, Estate Planning Myths, and you can have it by calling 888-930-1080. Again, that's 888-930-1080. We'll mail it or email it, whichever you prefer. Again, that number's 888-930-1080. You're tuned in to the Retirement Income Source. I'm Tim Sparks, your host, and we're talking about estate planning basics. If you ask 9 out of 10 people what estate planning is, and they'll respond almost every time that it's just for wealthy people. Well, today, in my personal opinion, that's not the case. Because if you have assets and you have a home, then you should have some kind of an estate plan. Because at the end of the day, if you don't have one, the state will provide one for you. You may not realize that you can Google this and you can actually find out what is the state of Kentucky's will. How do they divvy out assets? And so, and for example, I'm sure some of the things I've read, it's 50% goes to the spouse, and the other 50% will go to the closest other relatives, like the children. And then it goes right down the line. So in other words, there may be some people there that you may not want that money to go to at your passing. So you want to be able to control that from the will, from the grave by using a will, but being more specific. Also keep in mind that if you've got to have other documents beside a will, like durable power of attorney, and I explained that just a few minutes ago, and a living will, and have an advance directive that will carry out your wishes in case you're, in the hospital, or you're in coma, or if you're on that machine, they're just trying to keep you alive. And every day you stay in the hospital cost continues to accrue, and that is affecting your estate. You got healthcare power of attorneys. There's other documents as well. And by the way, people, I want to let you know, as a disclaimer, I am not an attorney, or I'm not an accountant. But we have to make it our business as a financial planner / financial advisor to be aware of both estate planning, the basics, and also taxes. Why? Because we deal with that with our own clients. We will ask questions like, do you have your will or do you have a trust when they become a client? Why? Because we want to make sure these documents are in place, because we've seen them and how important they are whenever these things arise as we get older and on down the road, because we want to plan for them and just in case they do occur. You see, that's what we have these professionals for and what they do. We're just involved in financial planning, and keep in mind, when it comes to estate planning, it has something to do with accumulation, preservation, and the distribution of assets. So we're really the first line of contact when these things will actually change. And not only that, a lot of times an estate plan, and I know this by talking to clients, and when we ask them, do you have a will, they almost every time tell, I need to update it. Why? Because they may have had one from years ago, now they need to update it. Well, now is better than waiting to be able to get that updated. And here recently, we've had people come in, they had a will, and they tell me they need to update it, and they tell me the reasons why, and then we set them in front of an attorney and be able to get their everything updated, because things change. Your kids may get married, and so you may want to, just like we had a client that had an existing trust, and so she's saying, I need to update my trust. I'm going to change the successor trustee, and et cetera, et cetera. Again, I don't do that, but we can help her by giving her, a really good qualified and estate attorney can be able to help her to get those documents in place and those amendments in place, or whatever they suggest. I don't get into that side of the equation because that's not what I do, but I want to make sure that they get those problems taken care of. So if you want to learn more about Income First Methods, which is about retirement planning, what we primarily focus on and specialize in, then I got an excellent book written by CPA Michael Easton, Common Sense Income Strategies. You're going to learn preservation techniques that are extremely important when it comes to the estate you want to leave. Think about it. If you don't have an estate, the point of leaving assets behind because you spent all the money for the plan winds up not working out, and therefore it's because you didn't do things on the front end. You hoped to have a preservation, but you really didn't do the right things to preserve your estate. And I got a free copy for the first 5 callers of today's retirement income source by calling 888-930-1080. Again, that's 888-930-1080. And we'll mail this out to you for one of the first 5 callers, free, no obligation book, 888-930-1080. You're tuned in to the Retirement Income Source with Tim Sparks. I'll be right back. Welcome back to the Retirement Income Source with Tim Sparks, your host, sponsored by Sparks Financial Group, a firm right here in the heart of the Bluegrass, Lexington, Kentucky. Today, we're talking about the estate planning basics. Most people are really They overthink it sometimes, in my opinion, about what to do. Sometimes there's reasons why. It's financially. They don't want to really pay for an expensive estate plan. I get it. I understand that. But, I'm fond of a good philosophy that I live by, that is, keep things simple unless there's a reason to complicate them. When it comes to estate planning, a little more complexity often make things simpler in the end. You see, most people think that they're unsure whether they need a will or they need a trust. And at least if you have a will, it's better than nothing than a estates plan. But, the purpose of this show is just to give you some ideas and thoughts of what we've run across when it comes to a trust made more sense in some situations. And I know that by, what the attorney set forth for their clients, and also with clients that we met with that had already estate plans in place. And, and I'm fond of a good philosophy to live by, and that is to keep things simple unless there's a reason to complicate them. When it comes to estate planning, a little bit more complexity often makes things simpler in the end. And what I mean by that right there is if you do just a traditional will, then there could be some complexity in the end. In other words, because sometimes simple means complexity in the end versus complexity on the front end. That means you do a little bit more work on the front end, and I'll explain to you a little later in the show why doing the footwork and putting a trust together, and I'm talking about just a standard revocable trust. To me, in my personal opinion, is better than a will. Then I would. What happens is it makes it simpler on the back end, and especially when it comes to fees. You see, when you have a will, you have things that that you got to be concerned about on the back end, because it's got to go through probate court. That means there's going to be probate court involved, and there's fees involved there, and then there could be more attorney fees involved because you have a will. What I mean is some people may disagree in the will and they can contest it. So that means they may get a representative. And by the way, people, I've actually seen this happen. And of course, last but not least, and of course, this is not always the case, not unless it's a high net worth individual. You got estate taxes on the back end. So will in of itself is not going to be able to alleviate that. And of course, even wealthy people know that. That's the reason why that they know they have to have an estate plan, and so they want to be able to start chiseling off part of their estate to keep it below the thresholds. And as we all know, when it comes to estate taxes, if you're a single and if your estate is less than 13.6 million or whatever the number is today, it's close to that number. Then you probably have nothing to worry about, not unless your estate is, 12 million and you're really close. And now it's indexed for inflation, but estate tax laws change, so you have to be aware of that. And if you're married, then it's over 27 million. And so, and what are the estate taxes today? Well, up to the first million, it's up to 40%. It's tiered, so you can Google that if you want to look at that, and then anything after that million is 40%. Most of the cases, I'm willing to bet most people are not having to worry about estate taxes. So just to keep in mind, a will. The whole point is this: the will could be very simple on the front end and create a lot of complexity on the back end, and you need to understand what those complexities could be. Because if you have more than one child, have you ever known 2 children or 3 or 5 children agree with anything? There's a good reason to have a good sound estate plan. And another thing too, if you're still going to use the will, I'm not trying to tell you how to set up your estate plan. I get it. Some people, a will is good enough for them. Whatever you do, get the corresponding documents, the durable power of attorney, and those other documents. And stay tuned as you listen to the show. We're going to talk about what the purposes of those documents are. Look at the cost of what it takes today to do an estate plan. Well, it takes an attorney to set that up. There's always going to be cost, right, to do that. That's okay. And you're trying to avoid expensive additional costs in the future, including if you have your wishes out correctly and you've even had the family meeting, you talk to your children, you can minimize the unnecessary attorney fees that could be used by these, again, these, disinherited children. It could happen. I've seen that happen. Or the will wasn't, there was assets that was left out, so therefore it gets contested. So therefore there's going to be additional attorney fees. And so you want to make sure you get all these things, on the front end to minimize on the back end. Unnecessary attorney fees, and also unnecessary probate fees. So, with that being said, I like to get a commission report in your hand called the Estate Planning Myths. And this is a commission report, and it can be yours if you call our show, reach out to Retirement Income Source, 888-930-1080. Again, that's 888-930-1080. We'll mail this or email it, whichever you prefer. Again, that number is 888-930-1080. You're tuned in to the Retirement Income Source. This is Tim Sparks, and we're talking about the estate planning basics. If you ask 9 out of 10 people about estate planning, and most people will respond it's only for the wealthy, and I'm going to be honest with you, that is not the case. We are starting to see where these documents have come into place more often than not. I've been doing this for 20 years. We work with people in retirement. And when you work with people in retirement, we come across, where people's passed away early, average life expectancy, and lived longer and passed away. And with that being said, they had the right documents in place, and we've seen where there's been a lot of advantages by doing a really good estate plan. And thank goodness there's attorneys out there that can get this stuff in play. So, we work with a national group of attorneys that work, and this is because we have clients that are out of state and so forth that are wanting direction about who to do their estate plan. And we also work with a local attorney as well. And it doesn't matter if it's elder care law, whatever it may be, all those specialties that they do, they bring to the table. We're all about making sure that the client is getting the plan that they need. And sometimes they ask us those questions first before they start trying to look for an attorney that will be able to do that. I had a client in just the other day that came in from our estate planning course we taught here locally, here about a week or two ago. And they had an estate plan done in the trust and had everything already planned out. And they had a trust and everything done in the state of Michigan. And they wanted to know, was the trust okay in the state of Kentucky? And I said, well, I'm not an estate attorney, but I do know, and everything I've read, because we have an estate attorney that is, a financial advisor in our group that has told us anytime you move across another state, you should always have it looked at. So that's exactly what we did. And so once, when he came in and, we put him before an attorney that can be able to answer those questions and get him back on the right track. Because again, anytime you cross over another state, there's certain state laws that may affect that particular trust. And again, that's not my expertise. Only an attorney can answer those questions. But whatever you do an estate plan. Have a living will with an advance directive. Have a durable power of attorney, a health power of attorney. You don't know when these documents may come into play. You may not use none of them, but at least you have them in place. But I can tell you right now, of those documents, it seems like I see them being utilized more often than not. Thank goodness our clients have those in place. The other day I had a client call their office, 88 years old, and needs us to contact a local rehabilitation center to let them know that he can financially take care of his bill and stuff, because he's probably going to be in there for the next 3 to 6 months. And we have limitations because that's, those are HIPAA laws and stuff. But I do know that he has a power of attorney, durable power of attorney in place. And then so therefore he has to have somebody else to be able to, that in this case, a durable power of attorney is one person that can reach out and be able to handle this discussion with this particular facility. I can't do that. But I can tell you at the end of the day, I know where to get the answers. You don't have to be the smartest man in the tool shed. You just got to know where to get the answers, like Andrew Carnegie once said. So if you want to learn more about preservation techniques, income first methods is the way you preserve your principal, so that way you can have an estate to leave behind. Or you want an inflation hedge, or you may need it because you're self-insuring yourself for the purpose of long-term care. I got a great book. It talks about these techniques. Again, great preservation techniques, because we're talking about preservation, which is a part of a sound estate plan. And it's written by Michael Easton, CPA, called Common Sense Income Strategies. And I got a free copy for the first 5 callers of today's retirement income source by calling 888-930-1080. Again, that's 888-930-1080, and we'll mail this out to you if you're one of the first 5 callers. Free, no obligation book, 888-930-1080. You're tuned in to the Retirement Income Source. This is Tim Sparks. We'll be right back. You're tuned in to the Retirement Income Source with Tim Sparks, your host. And our show is sponsored by Sparks Financial Group, a financial firm right here in the heart of the bluegrass, Lexington, Kentucky. Today we're talking about estate planning basics. But before we get there, I want to let y'all know that my book, The Retirement Income Shift, How to Get the Most Mileage Out of Your Money, is right now on pre-order status with both Barnes & Noble and Amazon. And our goal is it will make it to number 1 probably within the next few months after, I think the release date is October 22nd. And we're really looking forward to this because, you know, a lot of stuff I talk about on the show, I also have emphasized in the book and actually go a little bit deeper than that. So just to let y'all know that anybody that listens to the show in the near future, after October 22nd, you'll be able to call in and be able to get a chance to be able to get a free book. And we're actually going to have a book signing. It's either going to be at Barnes & Noble or here. We're still trying to find the appropriate place for that. And I'm expecting to probably give away 300 to 400 books that day. And so anyway, I just thought I'd take a side trip there real quick to let you know that our book is out. You can actually go online and actually see that, The Retirement Income Shift, how to get the most mileage out of your money. To me, getting the most mileage to me is very applicable to our show today because we're talking about estate planning basics. If I'm going to have an estate plan, if I want to be efficient, then I want to preserve efficiently as well, so that way I can have something to leave to my children or whoever it may be, or even some people may have charities and so forth. It's really nice. If you remember, was it Hannibal? I said used to say on one of my favorite show with him and Mr. T. So I love it when the plan goes as planned. And again, when it comes to estate planning, we want to be able to put forth the best plan. Well, with that being said, when I think of estate planning, I think of the old movie that comes out every Christmas called The Scrooge. And the Scrooge, you have, he was visited by 3 ghosts. And the first ghost was the past, kind of evolved who Scrooge was, and then the present circumstances and how he was getting, as we already know, his attitude toward the people he worked with and so forth. And then he had his future, which scared him half to death. Well, today we're talking about estate planning, about present, what you can do right now, and future, about what you want to do to prevent anything major blowing up your estate plan. That's the whole goal. And so you're the one that be able to establish that, so that way you're not visited by the future ghost. Now, that's a silly analogy, but that's just my way of being able to help people to understand how important it is to have an estate plan. And by the way, I grew up, my dad ingrained that in me ever since I was probably in my 20s about having an estate plan. I mean, he's had one since he was like in his mid 40s. and he's got several trusts put in place, and so to me, estate planning. As a matter of fact, I'm a real big fan of having trust. They serve a purpose. Sometimes people don't like to pay the money, but what I have seen on the back end, I'd rather it pales in comparison what it costs sometimes on the back end by just simply taking care of the complexity of it on the front end. That's the reason I'd rather have a complicated way of getting it done. There's a little work on the front end, and then make it simpler on the back end. And as things change, I want to make amendments to that trust as well. But we've had we've talked about attorney fees. These are the reason why we do estate planning, so that way we can minimize costs into the future. Why have children find their own attorneys? Because we didn't do the right estate plan in the first place. That means they could contest the trust. So there's unnecessary attorney fees on the back end. You could have avoided probate fees. Keep in mind the cash register is running. If it goes through probate, if you have a will or if you don't have a will, it doesn't really matter. Either way, you're going to go through probate, and that's the reason why sometimes people would prefer to have a trust. And then you want to be able to minimize estate taxes if your estate is above a certain amount. Right now, that's $13.6 million if you're single, over $27 million if you're married, filing jointly. Well, let's go further than that. There's other estate leakage that you can control as well that could also occur at passing and also occurs right now, and it's called income taxes. So if you think about it for a moment, what assets do you leave behind that are continually to be income taxable? Most of you probably, if you don't know, then I'm going to tell you, it's your IRAs, your 401ks, your 403bs, wherever you leave your employer plan, retirement plans at, those are income taxable because the children are going to have to pay income taxes until the money is gone. Sometimes people want to be able to minimize income tax. You can't eliminate them because these are always going to be income taxable. With thanks to the Secure Act, in probably a negative way, used to be you can stretch an IRA out over the lifetime of your children. You can no longer do that. You only get a stretch of 10 years. Also, you have investment management fees. Sometimes people pay unnecessary fees in the management of their money. Fees, once you pay them out, it's just like taxes, you don't never get them back, and plus they can erode your principal in the long run. You also have lawsuits. So in other words, people sometimes they'll do certain trusts and stuff to put in place because they're wanting to minimize lawsuits. And then you got catastrophic medical care. Now, when I think of catastrophic medical care, I'm talking about the last 5-yard line of life. This is whenever people go into a nursing home or they need some kind of a home health care. This can erode your principal of your assets. Another reason to preserve your assets, if you're one of those that have decided to self-insure yourself and not buy long-term care insurance, then you're going to probably run the risk of spending down your principal, and that's okay, but keep in mind you got your spouse to be mindful of as well. And so there is a commission report I want to get in your hand called Don't Let Long-Term Care Be Your Financial Blind Spot. So you want to be able to understand that there's ways to be able to minimize this catastrophic medical care event if it was to occur by having long-term care insurance, and then there's different types of long-term care out there. So you can get this commission report by calling 888-930-1080. Again, that's 888-930-1080, and we will mail this to you or email it to you, whichever you prefer. Again, that's 888-930-1080. You're tuned in to the Retirement Income Source. This is Tim Sparks, and we're talking about estate planning basics. We're talking right now about estate leakage, things that you can control while you have the ability to control. As we get older, sometimes we kind of don't have the same mindset as maybe when we get closer to our 80s. I know this with my own parents right now, where they're needing to have some advice along the way, even though they hate to let go of that, and I get it. But one of the things that we find that people don't realize is catastrophic medical care. And we were talking a little bit about it, about the need of having long-term care insurance if you can afford it. Some people will not be able to afford it, and if you cannot afford to have long-term care insurance, which will prevent you from spending down your assets, because if you have to have it, all you got to do is check around. Anybody can tell you the cost of long-term care going into a nursing home today is $120,000, $150,000 a year. Home health care, I know one client told me that they were spending $18,000 a month for their father, and we're talking about a frugal lady, and again, it costed her that much per month, a hit on the estate. Thank goodness they had an estate. But if their father lived for a few years, they would have spent $600,000 to $800,000 of their own assets that he wanted to pass down. So they did some trust and stuff to be able to protect some of those. But again, that is something you would take up with an estate attorney. And if you're struggling about who to use as an estate attorney, you can always call our office, set up an appointment with myself, and then we can have a discussion and be able to set you up with the right estate attorney, because they both have their differences of who they are and what they suggest, and we want to make sure we put you in the right one. If you want somebody local, then we have somebody local. If you want somebody that put together really sound estate planning, you're just trying to minimize cost, then we have another one that we work with that can actually put those plans before you, so that way you can have the right plan. And then, of course, another estate leakage, and probably the biggest one, and it's got a lot to do with our show, is asset spend down. In other words, accidental asset spend down. A lot of people by accident will spend down their assets because they don't understand reverse dollar cost averaging when they're in retirement. If you think about it for a moment, when you accumulate assets, you're buying shares in mutual funds in your 401k. I'm just going to pick on the 401k. You can fit any kind of vehicle into this that you invest in. And if you're using mutual funds and ETFs, they're very similar in a lot of ways. ETFs, I think, are a little bit better than mutual funds. But you're accumulating wealth and you're buying shares, and you did that for 30 to 40 years. And so, but when you go into retirement, you're no longer actually accumulating wealth from a standpoint as far as buying shares. So as you were buying shares, you were dollar cost averaging, that worked in your favor. Plus 40 years ago, the S&P 500 was less than it is today, right? And so over time, your assets accumulated, and they went up in value because of how much you were contributing. You were buying shares from a much lesser standpoint than you are today. So, but when you go into retirement, now you're starting to sell shares. And what I have found, the reason why people are selling shares is because they didn't transition to a successful retirement philosophy called investing for income, interest and dividends. They stuck with the methods that got them to retirement, and they think those same methods will get them through retirement. The only way those methods will work is if you have the wind at your back long enough for that to work. If you have the next 10 or 15 years and you get lucky like people did in the 90s, then yes, the markets are going to go up and you'll be fine. You have nothing to worry about. But keep in mind, that was by accident, and that was not an intentional preservation plan. Most people are concerned that may not happen, and they need to plan for the other case in case it doesn't happen. So they have a defensive mechanism put into place, or they should, and that's the purpose of this show, is to be able to help you to preserve your wealth, so that way you can have assets to pass down in your estate plan, and you want to be able to avoid that at all costs, so that way you're not accidentally spending your principal. Because keep in mind, people, you're not accumulating shares no more. The only way you can accumulate shares if you're not taking withdrawals at all in your portfolio while you're in retirement. I don't hardly know anybody that doesn't need income from the retirement resources that they saved. And Because think about it, if you got $1 million saved, you only got about $10,000 a year coming in dividends if you're in all growth and you're doing it on your own. If you add a financial advisor to that, you have nothing because the fee has been assessed to that, and that subtracts that amount from there. So you have nothing. You're not buying shares at all. You're not accumulating in that way. Most people, if they're going to be in that type of method, using that type of method, then they want to have dividend-paying stocks where they can still do that because the dividends stocks allow them to continue to buy shares. But that's not the plan that most people are doing. So accidental asset spin down is extremely important to be able to have the right tools in place so that way you don't have to worry about the leakage of have a lesser estate to be able to pass on to your children. There is a way to possibly have your cake and eat it too while you're going through your retirement spending years. If you want to know more about preservation methods, in other words, the transition into retirement, now it's time to retire successfully just like you accumulated successfully, then I want to get a book in your hand by Michael Easton, CPA, on common sense income strategies. It's great preservation techniques to be able to help you to preserve your legacy so that way you can leave it as much as you can to your spouse and your children. And I got a free copy for the first 5 callers of today's retirement income source by calling 888-930-1080. Again, that's 888-930-1080. And we'll mail this book out to you if you're one of the first 5 callers. Free, no obligation book, 888-930-1080. You're listening to the Retirement Income Source. This is Tim Sparks. We'll be right back for some great information, and stay tuned as we start talking about the difference between wills and trusts, and I'm going to give you a great story to distinct the difference between these two and why it was important that the trust was a better decision. Talk to you and more on that in just a minute. Welcome back to the Retirement Income Source with Tim Sparks, your host, and our show is sponsored by Sparks Financial Group, financial planning firm right here in the heart of Bluegrass, Lexington, Kentucky. Today we're talking about estate planning basics. Here's what I'm going to tell you. We just got finished doing estate planning basics class for a couple nights and got another one coming up October 3rd and October 10th. And of all the topics that we educate people on, this is the hottest topic. And because again, people when they go into retirement, they want to do their due diligence, and so we sometimes people wonder, okay, why am I here? Why am I qualified to? I'm not an attorney by no means, but we're kind of the first line of contact with, and a lot of attorneys out there have relationship with financial advisors, and if they don't, they should, because we're again the first line of contact. Because one of the prudent things to do when you're working with people in retirement is to make sure that they have wills or trust and so forth. Because I'm a firm believer in it, as I shared with that with you a little while ago. But at the break, I said, we're going to talk a little bit about, what's the difference between a will and trust? Well, they both will they both will do the disposition of assets, but one, you got to understand one thing. When it comes to a will is guaranteed to go through probate, and if you don't have a will, if you forgot to, or you passed away without a will, then it's guaranteed to go through probate just as well. It doesn't really matter, it's all going to go through probate, because probate, the purpose of that is to prove. That's what probate means. And sometimes I've seen where things went through smoothly. Probate does still mean that there's going to be some cost involved, but at the end of the day, people, you don't know whether the will's for you, because it's the other things you're also got to be concerned about. And so I had a client who was a trustee upon her second husband's death back in 2016. Now when he passed away, he passed away like 2 years prior. So she really didn't do anything for a couple years. They both were married, had separate marriages in the past. She lost her husband, the first husband, and again now she's lost her other husband, the one we're referring to. He had 5 children. He had 5 rental properties. Yeah, just perfect, perfect hand and ball and glove here. And he had a small farm, about 70 acres, and they both lived there until he passed away. And then when I met her, she sold the house and farm and had about $500,000 to invest. And that's where I kind of came across her, and because she was a sister of a client of ours. And so she was telling me, this was after she had became a client, on showing her how to live off her income from her $500,000, and she told me emphatically she had to preserve that $500,000 as much as possible because that was her second husband's wish, and she was the trustee of the trust. Well, also in the trust, while she was the trustee, and this is why I think it's so important to go over this, is the 5 rental properties was put all 5 of the children supposed to get one apiece. And plus they would get the $500,000. In this case, she reserved the right to sell the farm unless the money was for some kind of extended health care need. And that was kind of his and her arrangement. While she was alive, the rental property was to suffice her income needs. And by the way, she had her own rental property, which she was going to pass away. When she passed away, she was going to give it to her son as well. She lost a son. She did have 2, and then she lost one in quite a few years prior to me meeting with her. But the thing is, what she was telling me was she started encountering problems with her stepchildren, which was his children. And a lot of that, I think, came because the stepchildren was not aware that Dad had put a trust in place, and she was the trustee. So they really truly had a hard time coming in and being able to get their inheritance right away because of, to me, a trust really worked very well here. And 2 of the children was really, bashing her, cussing her out. And matter of fact, this lady was like 81 years old when I met her. She couldn't handle all this stuff, and she even got to the point where she was thinking about negotiating. And her sister told her absolutely do not do that because it was going to affect her own retirement. Because again, that was the wish of her past dying husband. And so, keep in mind, people. And the point of this right here, her being the trustee of this trust, and this was his wish, and maybe because he knew his children and that they would probably do this. And the other 3 children were very amicable about everything, and they were okay with it, but the other 2 were not. But if she had chosen a will instead of he had chosen a will instead of a trust, then my question would be, would if the 2 children contested it to the point where it could have they would have wound up with the 2 properties. Maybe all 5 would have came up to her properties, because at the end of the day, the will has to go through probate. The will will be challenged and can be contested, and if it's contested, then that means there's going to have to be necessary attorney fees involved as well, where the trust kind of prevented that. So, and I'm outside looking here, looking in on this particular situation and trying to give you my ins and outs of why the attorney, I think, set this up, and most importantly, why the dad had set this up. And so keep in mind, a will is going to go through probate, and if you don't have a will, it's also going to go through probate, and you're going to go through the probate process, and sometimes you may not like the way the state does it, so I'm willing to bet you can probably have a better plan than the state can provide for you, because there could be children or other people you want to leave assets to in your will that the state may not follow, so you have to be careful with that. And also, if if you have children that have, drug issues or alcoholic issues, or if you have children that are spendthrifts, there's other reasons why that trust can come into play. Again, keep in mind, it's all about leaving a legacy the way you want to leave it. And as my dad always told me, a trust fund is something that governs your ideas, your estate plan, and make sure it goes to who you want it to. And that's all it is. You're controlling it from the grave. It's true that the spouse will wind up taking over the trust if you're married, but after that, a successor trustee comes in and takes over the distribution of the assets, or whatever the language of that different trust. I didn't really get into irrevocable trusts and all those. Those are where specialization of attorneys require more work, and plus you got to know the pros and cons of those. But we've came up to the end of our show, and I would love to be able to talk more about estate planning, but again, our time has expired. But I want to get a great book in your hand for preservation techniques to your assets while you're alive, so that way you can leave the legacy you want, and a great book written by CPA Michael Easton called Common Sense Income Strategies. And I got a free copy for the first 5 callers of today's Retirement Income Source by calling 888-930-1080. Again, that's 888-930-1080. We'll mail this book out to you if you're one of the first 5 callers. Free, no obligation book, 888-930-1080. Always remember, preservation means more assets. You may not want to leave a big legacy, but you may need those assets if you're going to self-insure yourself in case you need long-term care, or if you want home health care, you want it first class, you want it in your home, and it's going to cost you money. The last thing you want to do is accidentally spend down your assets and you have nothing, and therefore you're forced to go into a nursing home. And not only that, you can the nursing homes can also put a lien on your home. So with that being said, I hope you've enjoyed the show. My name's Tim Sparks. You've been tuned in to the Retirement Income Source. We'll be back again next week for some more great information.